Welcome to the Warrant, the podcast series by C3, the Center for Criminal Justice Reform and Capacity Building. Today's session, we will be focusing on the use of forensic evidence in serious sexual violence cases. And unfortunately, when it comes to such cases, there's a high acquittal rate. And we wanted to discuss the reason behind this high acquittal rate while focusing on the use of forensic evidence. We've seen the utility of the use of forensic evidence in criminal trials, such as in the Zainab murder case and in the recent motorway incident case. However, we wanted to highlight certain challenges that arise when it comes to the use of such evidence for justice sector actors, such as in the collection and preservation of such evidence for investigators, and the subsequent use of such evidence in the criminal trial itself. To discuss all these issues, we have with us today Ms. Mavra Ghaznavi, who is a lawyer who focuses on criminal justice reform and has worked on key areas in the field in a project implemented by Adam Smith International. During this time, Mavra has developed SOPs and laws, conducted trainings, advised on strategic litigation, and reviewed data in order to assist the Punjab government in strengthening the investigation and prosecution of homicide and serious sexual violence cases. So welcome, Mavra.
Thank you.
We're happy to have you with us today. So before we start, I just wanted to ask you broadly, what are some of the main challenges that we face in the prosecution of serious sexual violence cases in Pakistan?
Thank you for that question, Zainab. I think there's two key cultural challenges that impede the prosecution and the investigation of serious sexual violence cases. Firstly, we have the issue of ocular testimony. Our criminal justice system is predicated on ocular testimony, or what we call oral testimony. And the issue is essentially that under Chapter 4 of the 1984 Qanun-e-Shahadat, all facts except the content of documents may be proved by oral evidence. And there's not enough real reliance on forensic or physical evidence in such cases. So what frequently happens in cases of serious sexual violence is that it essentially devolves into a he said versus she said situation, because each party will present their own witnesses. And even when you have strong corroborative evidence in the form of DNA evidence or other forensic or physical evidence, that's not given the same weightage as the oral testimony in these trials. The second issue that I want to highlight is the lack of reporting, the delayed reporting, and the resiling of survivors of sexual violence in these cases. And this is really, because there's an enormous amount of pressure in these cases to resile, societal pressure, family pressure. They also take an extraordinary amount of time in some situations. I recently read about a case in Karachi, which was, where the case began in 2001 and the judgment was finally passed in 2021. So that obviously means that a sexual violence case, if it lasts for 10 years, that means constant interruptions to the survivor's life, through major life events. They're getting married, having children, they're, working, doing all sorts of things, and their life seems to be on hold until this case is adjudicated. And, if it takes out 10 years of your life, that's a substantial amount of time. Then when we talk about pressure from family and society, there's a lot of powerful rape myths that exist in our society. And there's a lot of pressure on the victim to sort of resile and sort of go on with their life. There's also financial pressure because oftentimes the accused will either, offer money or will offer some sort of other benefit, transfer land or do something to have these charges dropped. There's also, physical violence can be also threatened in these cases. So if the accused puts sort of, threats to the family of the victim or to the victim directly, that obviously motivates the survivor to resile in these cases. And these, I mentioned rape myths, and we've seen recently in the motorway incident, the CPO victim blaming the survivor of that incident and suggesting that, if she hadn't been out at that time of night, or if she hadn't been out on her own, then the incident wouldn't have occurred. We also had the recent telethon with Imran Khan suggesting that sexual violence is the result of women not observing parda. And these are very powerful rape myths that continue to persist in our society and result in victim blaming and, underreporting of these cases or resiling. While we're talking about rape myths, another very powerful rape myth that continues to persist not only in Pakistan but everywhere in the world is that a survivor of sexual violence should have signs of resistance on their body to prove that they didn't consent. And this relies on a very limited understanding of stress responses to life and death situations. So the frequent view in these cases is that the survivor should have either fled the scene or should have fought. And in fighting should have obtained, marks, lacerations, bruises to their body, indicating that they mounted some sort of resistance. But this overlooks the fact that the most common response in life and death situations is freezing, where the victim, realizing that it's a situation where their life is in jeopardy, simply complies with the instructions of the assailant. It also overlooks the fact that in many cases, the assailant may have a weapon, a gun, or a knife, and, trying to resist the assailant when they have a weapon is sure to prove deadly for many sort of victims of sexual violence. So that sort of gives you an idea of the challenges that survivors of sexual violence face in Pakistan, and why we see even where cases, reach the trial stage, many victims resile because of the pressures from society, from family, or threats from the accused. So I hope that gives you a good sort of overview of the issues.
Thank you, Mavra, for providing a very great overview of the major challenges that prosecutors face in the prosecution of these cases. Touching upon some of these, such as the over-reliance on ocular evidence, resiling of witnesses, do we have any provisions in our domestic law or legislative framework that deal with witness protection in such cases? And broadly, what are the defects or lacunas in our legislative framework that lead to ineffective prosecution of such cases?
Thank you for that, Zainab. Yes, so in terms of witness protection, we do have witness protection legislation in Punjab. We have the Witness Protection Act and Witness Protection Rules. And within these rules, there is, in fact, a provision which states that the court will forbid a question to the victim of a sexual offense relating to any sexual behavior of the victim on any previous occasion with the accused or any other person, unless the question, in the opinion of the court, is a relevant fact of the case. Now, this was further strengthened in a recent judgment of the Supreme Court, where Justice Mansoor Ali Shah stated that when allowing or disallowing questions regarding the prior sexual history of the victim, the court should balance the rights of the accused to make a full defense and potential prejudice to the complainant's rights to dignity and privacy, to keep the scales of justice even for both. So, there are some provisions within our law that protect the victim from questions regarding their prior sexual history. But in my opinion, they don't really go far enough. And these are called rape shield laws in other jurisdictions. These essentially shield the victim from questions that might be prejudicial to a sexual violence case. And, in the US, there have been express rules of evidence for questioning survivors of sexual violence that go back 50 years. The first ones were introduced in 1978 in Michigan, and in Canada, in the UK, they were introduced around, I think, in the 80s. So in other jurisdictions, they have very, very specific circumstances outlined in which the defense counsel can produce evidence or introduce questions about the prior sexual history of the victim. For example, in the UK, there was a case where the survivor had been sexually assaulted while she was on holiday, and she'd been on holiday, a few days prior to the incident that was the focus of this case. So, they were able to introduce evidence from the previous sexual assault in the existing case to try and sort of prove that the assailant in that case wasn't responsible, and the sort of physical evidence that was collected in the UK related to the sexual assault that happened abroad. So, there's very specific sort of circumstances where you could allow such questions, and these are framed in rules of evidence in more sort of developed jurisdictions. So that's interesting to note. In terms of our legislative framework and other gaps that make it difficult to effectively prosecute or investigate such crimes, there are two other issues besides rape shield laws that I would like to highlight. First of all, there's the issue of medical legal practices. And what we have in Punjab is essentially a very fractured system. In 2015, the Punjab Health Department was actually bifurcated into the primary and secondary healthcare department and the specialized healthcare and medical education department. As a result of this bifurcation, what happened is that the Office of the Surgeon Medical Legal, which is sort of tasked with ensuring a high standard of medical legal practices in Punjab, became sort of the orphan child of the health department. There's no parent legislation establishing the Office of the Surgeon Medical Legal or subsidiary legislation. In fact, in the Punjab Rules of Business, there's no mention of the Office of the Surgeon Medical Legal at all. Which means that, there's a very confused system. In terms of jurisdiction and administration, it's also confused because you have certain hospitals and health facilities that fall under the primary and secondary healthcare department, and then some, such as teaching hospitals, which fall under the specialized healthcare department. This means that administratively, it's very difficult to have sort of a cohesive system of managing or ensuring quality medical legal practices across Punjab. It also means that the Office of the Surgeon Medical Legal is essentially declawed. It doesn't have any powers. It can't, for example, it can't bring in a medical legal officer and take their license away or, introduce some sort of disciplinary proceedings at all. The only thing that the Office of the Surgeon Medical Legal really does is at the, upon instruction from the two parent healthcare departments, they will train medical legal officers, or they will, as part of the review process or the review mechanism for medical legal evidence, they will, as the chairman of the standing board for medical legal examinations, they'll sort of review a medical legal case to see whether there was any discrepancies or whether a different opinion can be come to. Apart from that, they have very little authority, and it's very difficult for them also to arrange financing. There's no real budget for medical legal work in Punjab either. So that's also problematic. Another issue that needs to be addressed is also Section 510 of the Code of Criminal Procedure. Section 510 of the CRPC relates to government experts and reports produced by them. And these reports are admissible per se, which means that they can be admitted into evidence without the expert who produced the report having to come in and testify as to the contents of that report. There is a discretion within Section 510 allowing the court to call that expert in to provide, oral evidence regardless. But the issue really is that Section 510 is silent as far as DNA reports are concerned. There is mention of the chemical examiner, but that is a role that is now defunct in Punjab. All DNA or serology testing is done by the Punjab Forensic Science Agency, or PFSA. But there's no explicit mention in Section 510 of the PFSA or DNA reports. This is a lacuna that needs to be filled. And in fact, there's been a series of recent cases that talk about DNA evidence. You have the 2013 Salman Akram Raja case, in which the Supreme Court stated that DNA evidence is the gold standard. And DNA evidence must be collected in all sort of serious sexual violence cases. Then after that, I believe in 2016, you have the Azim Khan case that came before the Supreme Court, where doubt was raised about the admissibility of DNA reports. And the Supreme Court in that case relied on the language of Section 510 of the CRPC and stated that since DNA reports are not expressly mentioned in that provision, they are not admissible per se. And then more recently, I believe Mansoor Ali Shah, in a case discussing DNA evidence, said that, the government needs to revisit Section 510 and revise it, because DNA evidence, in the same way that any other report is produced by a government expert, should also be admissible per se. And, there is that discretionary provision within that section that allows the court to call upon that expert and ask them to come to court and provide oral testimony. But it's not necessary for the PFSA expert to be called in every single case, especially when, you have a province as large as Punjab. It's difficult for PFSA to ensure that their experts are available on a daily basis to attend to, cases that may be being heard in Layar or, other districts that are sort of far away from Lahore. So these are sort of three key lacunas within the law that need to be addressed as soon as possible by Parliament.
Thank you for that, Mavra. I'm sure our audience will find it very surprising that in this day and age, evidence such as DNA is not admissible per se under Section 510 CRPC, and that amendments are needed to our legislative framework in order to make it admissible per se. I understand from what you've told us that there have been recent judgments on this, which do state that such evidence should be admissible per se. However, it is very surprising that the law is in the state that it is in today. So broadly, I believe we've discussed the challenges that arise due to defects in our legislative framework. Now, I just wanted to come to some of the common mistakes that investigators make in the collection and preservation of such evidence, and whether there are protocols in place for them to follow, whether these are not being followed strictly. So what are the main issues that arise when it comes to the collection and preservation of such evidence?
Yes, there is actually quite a few issues in relation to the collection and preservation of forensic evidence. The first issue that I want to highlight is that frequently in cases of sexual violence, almost in all cases, in fact, reliance is placed exclusively on the medical legal examination. In cases of sexual violence, you will have multiple crime scenes. The body of the survivor is in itself a crime scene. The body of the accused persons is also a crime scene. And then the physical location where the act occurred or the offense occurred is also a crime scene. But unfortunately, investigators only sort of place emphasis on the medical legal of the survivor of the sexual assault, when in fact what they should be doing is arresting the accused as soon as possible and making sure that a medical legal of their person is done as well, and also securing the crime scene, the physical location where the incident occurred, and making sure that they collect all sorts of evidence that you could collect from that physical location as well. So from the physical location, you might be able to obtain CCTV footage. You'd be able to collect, DNA from sort of a plethora of physical objects in the location as well. If there's carpeting or bedding, all of that can be collected. If there's an attached bathroom or a washroom in the crime scene, you might be able to obtain a condom or blood or spit, or if the toilet hasn't been flushed, you can also get DNA evidence that way. You can also get it from glasses, plates, cigarette butts. All sorts of evidence can be collected. That would certainly help strengthen a sexual violence case. But unfortunately, what happens is that in these cases, there's a lack of coordination between first responders and investigators. The police has actually, they quite a while ago introduced a wireless system. And that means that when, a case is reported of sexual violence, the first responder is informed immediately and someone is dispatched to the location of the survivor ASAP. But also the wireless control is, accessible to the IO. So the IO, the investigating officer, is also immediately made aware of the case. The SHO, station house officer in the nearest police station, is also made aware. And despite the investigation officer and the SHO being made aware, what frequently happens is that they wait for the first responder to attend the crime scene. And then, after a day or a few days, they'll go and speak to the survivor and attend the crime scene. If you delay it by a day or a few days, then obviously you're going to have a loss of critical DNA evidence, the evidence that could be collected from the survivor, the accused, and the crime scene. Because, if the survivor has taken a bath or brushed their teeth or washed their clothes or disposed of their clothes, that means that you've lost critical evidence. The same with the, accused. You would expect that they would immediately after an incident go take a shower, change their clothes, burn their clothes perhaps, and you've lost critical evidence as well. And the crime scene, obviously, the longer you sort of leave it unsecured, the more likely you are to lose evidence. Within criminal investigations, there's something referred to as the golden hour, and that's the hour immediately after an incident has occurred, during which time you have the highest probability of collecting crucial evidence. And the more time lapses, the more sort of likely you are to have lost critical evidence. So that's, a major issue in these cases is the sort of delay that happens as a result of, investigation officers not responding immediately. And then the sort of emphasis placed on the medical legal examination of the survivor, whereas they should place sort of equal sort of importance on, the accused having a medical legal done and the crime scene being secured and evidence being collected from there. These are sort of the key areas that need to be looked at by the Punjab police specifically if they want to improve the way that these investigations are carried out.
Right. And in terms of resources that are provided to these investigators, are there any challenges with respect to those?
Absolutely. There's definitely challenges for investigators. So what we see is in other jurisdictions, police officers are equipped with early evidence collection kits, which allow the police to be able to collect evidence from the survivor as soon as possible. that is not too invasive. So, for example, the early evidence collection kit will allow them to take buccal swabs or oral swabs. If there's been oral penetration, then you don't want a situation where the survivor is not able to eat or drink water because they're waiting on the medical legal examination to take place. So to avoid that sort of needless discomfort for the survivor, early evidence collection kits are used by police officers to collect evidence as soon as possible that has the highest sort of probability of being lost. You also use these kits to collect evidence from under the fingernails, because if there has been some resistance and the victim was able to scratch the accused, you'd be able to collect important DNA evidence from under the fingernails. So, you don't want to basically place the survivor under this under needless discomfort. If you can collect evidence early that allows them to, comfortably then eat, drink, brush their teeth, wash their hands, things like that, then you want to allow them to be able to do that. The other issue is that we've seen that the first responders in these cases are often the dolphin squad, and they will arrive at the scene and be unable to do anything in terms of securing the crime scene until the police response unit vehicle arrives, or the PIRU vehicles. And I'm sure people watching or listening to this podcast have seen police vehicles which will have the PRU written across the side. Those vehicles actually have a kit in the back, which will include, certain materials that are needed for securing crime scenes. Unfortunately, there's not sort of regular funding of these resources. So often police officers will complain that they're not provided the equipment, for example, to secure the crime scene. Ordinarily, I'm sure listeners are familiar with crime scene tape, the bright yellow tape that you see around crime scenes. Often police officers in Pakistan or in Punjab are not equipped with that tape, which makes it difficult for them, obviously, to secure the crime scene. They also need specialized equipment to protect evidence. If you have a scene that's outdoors, for example, then you would want to establish a tent, so that evidence is protected from the elements. And unfortunately, that sort of specialized equipment is not available to police officers here. There are now discussions about, increasing as well the cost or the amount that is allocated for investigations of sexual violence. Unfortunately, police officers in Punjab are only allotted a couple of thousand rupees for these investigations. And they have to be able to cover the cost of petrol, the cost of medical legal equipment that might be needed to collect evidence, the cost of, also just transporting the victim back to their house after the medical legal. Often police officers will pay for a rickshaw or a taxi to take the survivor back to their home. Mm-hmm. So all of those costs need to be factored into investigations, and a more realistic figure needs to be allotted to sexual violence investigations. That's something that the police are currently looking into, and hopefully soon, these investigators will have the appropriate sum of money to be able to conduct an investigation without having to ask the survivor or their family for funds, which often happens.
Thank you for that, Mavra. We're hopeful that investigators will get the necessary resources that they need for the effective investigations of such offenses. Mm-hmm. Following up from that, I would just like to ask you whether there are any dedicated units for the collection and preservation. You mentioned the Dolphin Squad. Are they supposed to visit the crime scene first, or are there any other units that are meant to go in their place instead, but the Dolphin Squad is instead responding? So what is the sequence of events, or any dedicated unit that you would like to highlight?
Thank you for that. So actually, there are dedicated units in Punjab. As I mentioned earlier, we have the Punjab Forensic Science Agency, which was established in 2011, I believe. The Act for the Punjab Forensic Science Agency came out in 2007. And this was a project introduced by Shehbaz Sharif's government at a cost of 3 billion rupees. So a significant amount of money went into establishing this, a significant amount of resources. And PFSA is actually a world-class institution. They've been commended by forensic experts around the world, and their teams or their staff have actually attended trainings by the FBI in the US, by the top sort of forensic experts in the US, the UK, and other jurisdictions. So they're very, very highly qualified. And they, in fact, have a number of different departments within the agency that look at different types of evidence. So they have, the ballistics department, the DNA and serology department, the question documents department, and so forth. And amongst these departments, they have the crime scene investigation unit department. So they have, vehicles that respond to crime scenes, and they have crime scene investigators who are very well trained and very well equipped in collecting or, securing crime scenes and then collecting and securely packaging evidence. Unfortunately, they're grossly underutilized in Punjab. And sort of you touched upon, the sequence of events when, a crime is reported. Ordinarily, what happens is that after a case of sexual violence is reported, I mentioned the wireless system for communication within the police. What happens is that the first responder will immediately respond and speak to the survivor, but they will then wait for the PRU vehicle to arrive with the equipment needed to, if they decide to secure the crime scene, because I mentioned that frequently that doesn't happen in such cases. Then the PRU vehicle and the operational officers will secure the crime scene. And then, after that's sort of done, you would hope that the investigation officer will respond as immediately as possible. Mm-hmm. And once they're at the crime scene, they're in fact in charge of that crime scene and responsible for contacting PFSA. Once the investigation officer contacts PFSA, then PFSA will send out one of their dedicated crime scene investigation units to collect the necessary evidence. But as I mentioned, there's a lot of a lack of coordination that happens early on that needs to be addressed within the police. But the primary responsibility for contacting PFSA and getting that crime scene unit to the crime scene lies on the shoulders of the investigation officer, not the Dolphin Squad or the operational police officers.
Thank you, Mavra, for offering us that clarity on who the dedicated units are for the collection and preservation of such evidence. Now, I wanted to ask you whether currently there is enough adequate utilization of such forensic evidence, and whether there has been any legislative reform in order to strengthen the admissibility of such evidence. You mentioned that under Section 510 CRPC, DNA reports are not currently admissible as per the explicit language of the provision. But
admissible per se.
Admissible per se. But just other than that, broadly, have there been any recent amendments in our laws that would strengthen the admissibility of such evidence in SSV cases or generally other criminal offenses?
Sure. So the sort of first thing I want to talk about is, and to clear up any confusion, under the Qanun-e-Shahadat Order 1984, scientific evidence is allowed in cases, allowed to be admitted in cases. When we talk about evidence being admitted and being admitted per se, what we mean is that when evidence is admitted, it must be admitted in the process of oral evidence being given. So, for example, you have a PFSA officer or expert coming to court, giving their oral testimony, and in that process, handing in the sort of DNA report to the court as well, and then that DNA report being admitted. When you have a document that's admitted per se, it doesn't require the expert to come in and give that sort of oral testimony supporting that admitted report. So, our rules of evidence and our laws actually do recognize technical and scientific evidence. But there still remain some issues, and there's been sort of subsequent legislation that's tried to address these issues. So in 2016, there was a anti-rape sort of criminal amendment that sort of amended a number of laws. And what this did essentially was introduce provisions that would strengthen investigations of sexual assault. They introduced, fast-track judicial mechanisms. So, a sexual violence case has to be decided within, I think, 4 months. They introduced that requirement for DNA testing of the survivor as well as the accused. And in fact, has very strong language when it comes to the accused. The medical legal officer can force the accused or restrain the accused when conducting their medical legal exam. It also introduced the idea of conducting in-camera trials, sort of closing the court to the public. And it also introduced a provision prohibiting the publication of the name of the victim or the survivor, or any sort of information that could identify the survivor. So the 2016 legislation actually went quite far in terms of strengthening how cases of sexual violence are investigated and prosecuted. But unfortunately, what happened, as happens with a lot of legislation, is that it wasn't appropriately operationalized. And then we saw, in 2020, after the motorway incident, there was a sort of knee-jerk response from our government. It was a very sort of transparent PR exercise, really, and they hastily drafted 2 ordinances: the Anti-Rape Investigation and Trial Ordinance and the Criminal Law Amendment Ordinance. So there are some positive developments here that I want to commend. One of the ordinances, the Criminal Law Amendment Ordinance, is particularly important because it recognizes all types of survivors. So the provision for rape that was in our penal code, section 376, was previously focused on female victims. And what they've done is sort of make that provision gender neutral, recognizing that, male victims do exist. We all know that there's frequently reports of male children in particular being victimized. So that was an important development. But there's also a lot of issues here. So between the 2 amendments, what was seen was that there wasn't a lot of cohesion. One of the amendments talks about minors being those under the age of 16, while the other one recognizes only female victims. This is the Investigation and Trial Ordinance. It only recognizes female victims and recognizes minors under the age of 18. So there's sort of, 2 different definitions of survivors being given and 2 different definitions of minors in these ordinances, which is problematic. I want to highlight for listeners or viewers the recent statement of the Women's Action Forum and Women Lawyers Association. They issued a joint statement regarding the 2 ordinances, and I would encourage viewers to read these because they've highlighted how, firstly, the ordinances sort of undermine democratic processes. Ordinances are sort of an extraordinary measure taken by the president to introduce emergency legislation when Parliament is not in session. But to use this power so frequently really undermines our democracy. Legislation is a matter for Parliament, and it should be our Parliament as our elected representatives debating and reviewing old laws and ensuring some sort of cohesion within the law as well, or coherence really, and ensuring that these laws are also being operationalized. I'm focused on operationalization because as I mentioned, the 2016 amendment introduced a lot of important measures. We also have, as we talked about earlier, the Punjab Witness Protection Act, which includes measures to protect witnesses or survivors in cases of sexual violence as well. And these two ordinances sort of overlap with a lot of those provisions, which creates confusion. And also, there's slight differences in procedure as well that can be problematic. I also want to talk about how the investigation and trial ordinance banned the two-finger test. This is a provision that was already banned by the Lahore High Court. And then later on, the Supreme Court went further and also banned all forms of virginity testing. There's some confusion about virginity testing. People think that it's only the two-finger test, but hymen examination or looking at the hymen for old injuries is also a form of virginity testing. We frequently see when we read judgments, there's reference made to the hymen being old torn or the survivor being habitual based on the medical legal examination, and that is really because the hymen has been examined and the medical legal officer in that case determined that the survivor was sexually active. So the ordinances ban the two-finger test, but the Supreme Court took it further, which is important. And there's a lot of provisions within the investigation and trial ordinance in particular that are very problematic. They introduced an anti-rape crisis cell, which is supposed to, without delay, conduct the medical legal examination, preferably not later than 6 hours from the time of, the information being received. Although the 2016 amendment also talks about the medical legal exam being done without delay. They talk about, conducting the forensic analysis, registering the FIR, all of this. And this all requires a level of coordination as yet unseen in the criminal justice system. And it's all supposed to be led by the district commissioner or the deputy commissioner, who doesn't have the sort of specialized knowledge of these types of investigations to be able to manage all of this, nor do they have really the power to compel all of this. The Punjab Police is an independent institution and takes that independence very seriously. So compelling them to register an FIR when the police have determined there's not enough evidence, for example, to do so, that's going to create a lot of, infighting within the government. And then in terms of medical legal examinations being done as soon as possible, you're not really looking at the underlying issues when you say, it has to be done within 6 hours. What I've seen in my discussions with police officers and medical legal officers is that there's serious underlying issues. So what frequently happens is, first of all, each police station is assigned to a different medical legal facility or a different hospital or, health facility. And, if they transport the survivor to that health facility and find that there's no trained medical legal officers, they are then referred to, and usually in Punjab, it's the DHQ, they refer to Mia Munshi, which is not necessarily the nearest health facility for all police stations across Lahore. So that's very problematic, and it leads to unnecessary delay in terms of collecting the medical legal evidence. There's a serious need to ensure that all medical legal officers are adequately trained, and there's always one on staff in all the health facilities that are attached to police stations. With police stations being attached to different medical legal facilities or hospitals or health facilities, if they happen to go to a health facility closest to them, they'll often find, medical legal officers who either are not available, they're not on duty, they've taken leave and no one has been appointed as a replacement. They'll often find medical legal officers who are have been appointed on a contract. They're not permanent. So they have not been trained in medical legal evidence collection. They're not as, capable as permanent doctors. Then you have issues around medical legal officers just generally lacking the necessary training because the only time that they really study it is in their third year of their MBBS, and there's no subsequent training being offered. And, this sort of jurisdictional issue with police officers being referred to different hospitals and then, turning up and finding that a medical legal officer isn't available, that's an issue. And then there's also the fact that frequently medical legal officers are not dedicated MLOs. They're either assigned to the emergency department or the gynecology department, and you can't really expect a medical legal officer in the middle of, assisting a woman through labor to sort of drop that and then come and assist a survivor. It's very, very difficult to prioritize in that situation. If a woman is in labor for, say, 14 hours, there's not much a medical legal officer can do except tell the police officer to come again the next day. These are sort of the underlying issues that result in the medical legal examination being delayed, and simply, legislating and saying that, a medical legal exam has to be done within 6 hours is not really going to address the real issues.
Thank you for that, Mavra, for touching upon pressing issues that are still there that need reform in order to be addressed, and the recent amendments that have taken place in this area. I also wanted to thank you for joining us today for this very insightful discussion. And I also wanted to thank our audience for tuning in to The Warrant, which is a podcast series by C3. And we're hopeful that you'll tune in again for future podcasts in the future. Thank you so much.